Now we've got Michigan Law School professor and host of the Strict Scrutiny podcast, Leah Litman. Thanks for coming back on.
Thanks so much for having me.
So I want to discuss some of the recent Supreme Court rulings, but I actually want to start with a case that I think is just as dangerous. That's Moore versus Harper. It's a case that the court has agreed to hear for its next term. It was brought by Republicans in North Carolina who say that state courts should have no say on whether voting laws that they write or the maps that they adopt are constitutional. Basically would allow a Republican state legislature to have the final say no matter how gerrymandered or voter suppressed their states are. How much of a blinking red light is that case?
I mean, this is huge. Some people are calling it the coup case, and the case rests on what is called the independent state legislature theory. The idea that the federal constitution allows state legislatures and state legislatures alone, no other office of the state, to make the rules regarding federal elections. So in the context of this case, the state Supreme Court invalidated the state's legislative maps on the basis of the state constitution. It said partisan gerrymandering is unconstitutional under our state constitution. And what the Republicans are asking the Supreme Court to say is that state constitutions cannot constrain state legislatures when they are making the rules regarding federal elections. But that's insane. Like, of course, state constitutions constrain state legislatures. That's part of, the state governmental system.
If that were the case, I mean, if they weren't constrained by their own constitution, I mean, wouldn't that undermine all statutes contained within state constitutions? Like, wouldn't I mean, talk about slippery slope, right? Am I on the mark here?
So they're asking for this special rule only about the rules regarding federal elections. So what they say is, the Constitution singles out state legislatures, and those are the only body of the state. So state constitutions can bind state legislatures in all of the other areas, except when it comes to federal elections.
But these elections also occur with statewide positions. So it's not just federal positions that are being impacted here.
No, well, so one of the problems with this theory is it could result in the states having to operate two different sets of rules for federal elections versus state elections. Imagine you have a voter identification requirement and a state court strikes it down, under the state constitution. Then that would mean the state legislature's voter identification requirement would apply for federal elections, but it wouldn't for state elections. That's just chaos.
And now what would it mean in terms of sending electors? Because I know that there's been, grumblings about that. Like I know they'd be able to determine how elections are run, but I mean, how much latitude exactly would this give state legislatures on the electors front?
Yeah. So the idea that a state legislature can appoint electors, notwithstanding the votes that have already been cast, is a very warped variant of the independent state legislature theory. Now, they're related, they all kind of rest on this idea that the state legislature has plenary authority, like this super expansive authority over federal elections, but, they could be distinct, and they are distinct, under the case that's going to the Supreme Court. It's about whether state constitutions can invalidate, state election rules before an election. That wouldn't necessarily lead to a state legislature being able to throw out votes that are already cast, but they are related.
It'll be our funeral if we're sitting here saying, well, at least they're separate and one will never impact the other. Cut to, Yeah. Switching gears, we've got Dobbs. That was the case that overturned Roe. First off, I would recommend people watching and listening visit votesaveamerica.com/Roe if you're looking for ways to fight back against the attack on abortion rights. Your show, Strict Scrutiny, is part of Crooked Media that's responsible for Vote Save America. Vote Save America is one of, if not the best tool that we have. The questions that have popped up, and I'm not sure that you can answer these, but I think that it's worth asking them anyway. First, does the U.S. have the authority to install abortion clinics on federal property in states that have banned abortion? And is that property truly federal and beyond the jurisdiction of the states?
So the federal government could do that, but I don't think that doing so would actually ensure access to safe and legal abortion for two reasons. One is that under a federal law known as the Assimilative Crimes Act, federal law incorporates the law of the state where the federal property is located onto the federal property. Now, that wouldn't be a problem during the Biden administration, because the Biden administration would just say, obviously, we're not going to prosecute people, for violations of this federal law, for performing abortions. But the problem is the statute of limitations under most federal law is 5 years. That means you have 5 years to prosecute a crime after it's been committed. So let's imagine, Trump is elected to a second term in office, or Ron DeSantis is elected after the Biden administration, right, is finished. Then they could prosecute abortion providers who performed abortions on federal land, even if the Biden administration wasn't doing so. And so that's not a plan that actually ensures access to safe and legal abortion without exposing providers to criminal liability.
I mean, this is more in depth and in the weeds, but could they then get those abortions and then be pardoned or granted clemency by a Biden administration for all the people who did take advantage of, using those federal properties to get abortions while he was president?
So that might address the federal aspects, or like the federal crimes, but there are also real possibilities of possible state criminal proceedings. So imagine, someone living in a state that has banned abortion goes on to federal land in order to obtain an abortion. They would still have taken some steps and possibly made an agreement to have an abortion while they were on state land. And if that's right, then the state could prosecute them for obtaining or administering an abortion, and the president doesn't have the authority to pardon people for state crimes.
What about Native Americans, like putting abortion clinics on reservations? Is that property truly sovereign and beyond the jurisdiction of the state, or is it kind of in the same ballpark as the federal property?
So unfortunately, in light of the Supreme Court's decision from this past week in Castro Huerta versus Oklahoma, the Supreme Court held that states have concurrent jurisdiction on tribal lands, on reservation lands, for crimes involving non-Indians, even if, the victim of the crime is Native American. And so that possibility also isn't, one that would actually ensure access to abortion.
What about the fact that Merrick Garland has announced that states can't ban FDA-approved abortion pills like mifepristone? Is that something that you think would hold up when it's inevitably challenged in court? Like, is this something that people should get now and stock up on, for example?
So I hope it would hold up. And I believe that under the law as it stands today, once the FDA approves a drug and approves, a treatment plan for how that drug should be administered, then states can't prohibit it and basically take away the FDA's authority to do that. That being said, there are these kind of two pathways that states might use to, again, impede access to medication abortion. One is the major questions doctrine, which the Supreme Court just relied on this past week in order to invalidate the former Obama administration's clean power plan for regulating greenhouse gases. Under that doctrine, agencies can't adopt or pursue major questions or major initiatives without clear, explicit authorization from Congress. And I frankly don't know if the Supreme Court would say, the legality of an abortion is a major question that Congress didn't explicitly authorize the FDA to address, or at least to address, while preempting, that is, not allowing states to enforce contrary law. That's kind of one obstacle. The other is some states adopted kind of general abortion bans and did so before the FDA approved mifepristone and medication abortion. And so for those state laws, it's not totally clear, like, if the FDA's permission to use the drug does preempt these state laws predating the approval for medication abortion. And so, do I think the FDA is correct? Yes. Am I confident that this Supreme Court will say states can't enforce bans on medication abortion? No.
At this point, is there any real relying, and I know this is a broader question, but is there any real relying on good law when confronted with the question about what the Supreme Court is going to do? Like even if this is how it's been and it's always been a matter of the FDA, this has always been what the FDA has followed, even in instances where it was challenged, it was always upheld this way. And now, everything kind of goes out the window. So it's kind of just like having 6 Ron DeSantis's on the Supreme Court who can just kind of make it up as they go. So is there at this point, like, do we just have to assume, and I feel like I'm just answering my own question, but do we just have to assume that anything challenged at the Supreme Court that doesn't comport with the conclusion that they've already made is going to get struck down, or
I mean, I think that is a safe presumption, at least given all of what they did this past term. They're throwing out administrative agencies' authority. They're throwing out precedents protecting the right to an abortion. They're undoing a century-old gun control restriction in New York. They threw out, the idea that states didn't have concurrent jurisdiction over native lands. So they are broadly refashioning the law in their preferred direction. I think there are some things that, the federal government could do that are more likely to succeed, but I think the confrontation with the Supreme Court is not something that a Democratic administration and the Democratic Party can just ignore.
So that brings me to the obvious here, which is the question of how do we fix it? And I think that at this point, like I said, even if we are able to expand our Senate majority and hold the House and eliminate the filibuster and pass the Women's Health Protection Act, for example, the Supreme Court won't allow it to stand. It's clear the Supreme Court won't allow the federal government to combat climate change, that they won't, that they'll probably gut what's remaining of the Voting Rights Act and make these far-right state legislatures the final arbiter of their own maps, allowing them to entrench their own power completely unchecked. Is the one and only option here to expand the court?
I mean, I think that is an option that ensures Democratic legislation will actually get a fair shot at the Supreme Court. I also, frankly, think that's an option that ensures the court's powers could be curbed. Some people have proposed the idea that Congress could try to strip the Supreme Court's jurisdiction to decide whether the Women's Health Protection Act is constitutional. But I don't know that that would actually solve the problem, because what would prevent the Supreme Court from invalidating that legislation, stripping their jurisdiction to decide the constitutionality of federal abortion protection. So I think no matter what you want to do, if it's protect voting rights, if it's expand access to abortion, protect access to abortion, or if it is to alter the Supreme Court's role in our constitutional democracy, all of those paths go through the Supreme Court.
Because I feel like at this point, Republicans have figured out a way to completely circumvent both, any Democratic majority in Congress and the fact that we have a Democratic president by just basically putting any law forward, no matter how far right, how extreme, how unconstitutional, how illegal it is, knowing that it may get struck down at a district court, it may get struck down at an appeals court, but if and when it inevitably gets to the Supreme Court, they'll just uphold it with no, like I said, no concern for precedent or any legal basis, really. And so there is no need. I mean, if you're a Republican, there's no need to even have a majority in Congress or the presidency, because you can just put forward any batshit crazy law that you want, knowing that it's not going to be up to Congress to litigate this. It'll just be up to the courts to strike it down until it gets to the Supreme Court, and then they'll uphold it.
Right. And on top of that, it also means the Republican Party doesn't have to amend statutes that it doesn't like. It doesn't have to propose a bill to repeal the Voting Rights Act. It doesn't have to propose a bill to reduce the, EPA's ability to address climate change. It can just ask the Supreme Court to do that and to nullify and significantly water down, the statutes that we have now.
Just a general question. We'll end with this. You've focused heavily on the court. I've had you on after almost every major court decision. What's it like for you to see an institution that you obviously have reverence for, devolve basically into the Republican House Freedom Caucus?
So I'm not totally sure I would say I have a ton of reverence for the Supreme Court. I've said that. So I clerked on the Supreme Court during October term 2011, when the court heard the first constitutional challenge to the Affordable Care Act, the minimum coverage requirement, and only by a bare majority did it uphold that provision after, invalidating the Medicaid expansion in part. And I think I have always, since that point, been extremely nervous and skeptical about the court's authority. And the last 10 years have, I think, proven all of my worst fears correct and made it really impossible to just say everything at the court is fine, things are normal, we should accept the way things are, and how powerful the court has become.
We'll leave it there. Leah Litman, thank you so much for the work you're doing. And of course, if anybody listening or watching wants to hear more, there's the Strict Scrutiny podcast. So thank you again.
Thanks so much for having me.